Ladies and gentlemen, with another round of applause, help me welcome our speaker for today, the Honorable Minister for Lands and Natural Resources, Samuel Abu Jinapor.
Mr. Chairman, the representative of the Vice Chancellor of the Kwame Nkrumah University of Science and Technology, my dependable and able Deputy Minister, 5-term Member of Parliament, former Minister of Lands and Natural Resources, Honorable Collins Dauda, the Director of Legal Education, who doubles as the chair for this public lecture, leadership for Parliamentary Select Committee on Mines and Energy and Lands and Forestry, from both the majority and minority sides of Parliament, Chief Executive Officers of statutory corporations, captains of the mining industry, members of the bar, lecturers, and students of the Ghana School of Law, distinguished guests, ladies and gentlemen. It is great to be back here at the famous Kwame Nkrumah University of Science and Technology, and at this great hall, where about a decade and a half years ago, I had the privilege of being honored with a Bachelor of Science degree in physics. I thank the Chair and Director of Legal Education, who, while I was a student at the law school, taught me with distinction the law of conveyancing. Thank you, sir. Permit me to also thank our highly regarded Bompata Hene, who is representing our beloved King Otumfuo Osei-Tutu. I'm also pleased to be hosted by the Vice Chancellor of this noble university, Professor Mrs. Rita Akosua-Dixon, who doubles as a member of the Ministerial Advisory Board of the Ministry of Lands and Natural Resources, who has graciously sent a representative here. Let me express my sincerest gratitude to the leadership of the Students' Representative Council, SRC, of the Ghana School of Law, led by its president, Mr. Wanda Kuto, whom we can all attest has a long way ahead of him in the public life of our country, for settling on me to deliver the first SRC public lecture on the topic, quote, the legal regime of the mining sector in Ghana, history, challenges, and the way forward, end quote. Some few years ago, as a student of this noble university, and in the early days of my political career, I had the rare privilege of being at the forefront of the organization of a public lecture delivered by, as the lawyers will say, the foreign minister, as he then was, and now the distinguished president of the Republic, His Excellency Nana Addo Dankwa Akufo-Addo. From this same podium, little did I know at the time that my modest self will also be standing here performing a similar task years down the lane. Mr. Chairman, to attempt to meet the standards set at this podium by President Akufo-Addo will either be an exercise in futility or the beginning of a joke. Mr. Chairman, the story of the mining sector in Africa and its contribution to the socio-economic development has been somehow awful, to say the least. Our continent is blessed with large deposits of minerals, but the continent appears to suffer so much from the Dutch disease that one begins to wonder why it is not called the African disease. For example, using the World Bank's GDP per capita for the year 2020, 37 out of the 50 poorest countries by GDP per capita are from Africa. These include countries like Sierra Leone, rich in iron ore, diamonds, bauxite, and the largest rutile reserves in the world, Democratic Republic of Congo, which in the 1980s was the largest producer of cobalt, second largest producer of industrial diamonds, and fifth largest producer of copper, and Guinea, which holds the world's largest reserves of bauxite. Indeed, available data shows that even within the continent, non-monetary welfare indicators are weaker in resource-rich countries than countries without mineral resources. It is almost becoming like a punishment to live in a resource-rich country. A 2017 report co-published by the French Development Agency and the World Bank shows that in resource-rich countries, as compared to non-resource-rich countries, literacy rates are 3.1 percentage points lower. Life expectancy is 4.5 years shorter. Malnutrition among women is 3.7 percentage points higher. And life expectancy is 4.5 years shorter. In plain language, therefore, If you live in a resource-rich country in Africa, you are more likely to be malnourished, illiterate, poor, and eventually die earlier than others in non-resource-rich countries on the continent. These grim statistics make the call for an examination of the legal regime of our mining industry more imperative, and there could not have been any better time to do this than the time the government is pursuing measures to sanitize the mining industry and make Ghana the mining hub of Africa. Let me, however, admit at the outset that it is impossible to exhaust this subject in a single public lecture. Access to land for mining alone can be the subject of an entire PhD thesis. I do not, therefore, seek within this hour or so to exhaust the subject for today. What I seek to do is to draw inspiration from the history of mining and its regulations and how that should inspire policy considerations for the development of our mining industry for the benefit of the country and its people. History of the legal regime of the mining industry, the pre-colonial era. Mr. Chairman, there is still some dispute among scholars about the exact origin of mining, not only in Ghana, but across the West African sub-region. This, perhaps, is due to the oral tradition that has characterized African history. While some scholars argue that gold mining has been carried on in Ghana since time immemorial, others trace the history to sometime around 6th century BC, before the Phoenician sailors sailed around Africa. What is, however, not in doubt is that gold mining began in Ghana long before the arrival of the first Europeans, the Portuguese, on the shores of our country sometime in 1471. History has it that gold trading from Akan areas was one of the major commodities for the trans-Saharan caravan trade, with the gold sold through Morocco and Egypt to medieval and Renaissance Europe. Asante, Denchira, Achim, Wasa, Ahanta, Owahin, Nzema, Asen, Seshi, and Chifu are some of the areas early tradition mentioned as being rich in gold. Among the Akans, generally, gold dust or sikafutro was the main currency for trading. Indeed, the motivation for the Portuguese sailing to West Africa was to shore up depleting gold reserves in Lisbon. It is also said that the name Elmina, derived from the Portuguese word, quote, Elmina, end quote, meaning the mine, was given by Portuguese who were astounded by the large quantities of gold mined at that part of the coast. Of course, the name Gold Coast also resulted from the abundance of gold in the region, which later became the attraction for European commerce, with the Dutch and the English joining the Portuguese. Mr. Chairman, among the accounts, gold was regarded as sacred, to be mined only for the good of the community. Thus, when the two mines the Portuguese built in Abrobi and Aboasi in the 17th century collapsed, it was attributed to supernatural vengeance on the Portuguese for attempting to extract gold for their benefit rather than the good of the community. Although later literature attributes the collapse of the mines to an earthquake and badly shored tunnels, for the next 2 centuries, the Europeans stayed off mining and only resorted to barter trading in gold. As a result, gold mining remained the reserve of the local people. The method of mining at this time was largely about panning gold along the banks of streams, rivers, coastal areas, and sand, usually after rainstorm. Ankobra, Ofing, Tano, and Birim were the major sources of gold. This method of mining continued to somewhere the middle of the 18th century, when surface gold became almost depleted. Then people resorted to other methods like dredging of riverbeds and pit mining, with simple tools like hammers, chisels, digging holes, and obviously lamps lighted by palm oil to give them visibility in the pit. There was also deep shaft mining, usually done during the dry seasons. Between 1493 and 1600 alone, there were an estimated 30 gold mines in the country, contributing about 36% of the total world gold output. And between 1471 and 1750, it is estimated that some 40,000 ounces of gold was exported from Ghana every year, with the quantities decreasing to an average of 10,000 ounces between 1751 and 1800 due to the depletion of surface gold. All this time, there was no statutory regulation for mining. Indeed, the only law at the time was customary law. Land was owned by the stools, kings, and families, and the owner of the land owned every mineral on the land. The Latin maxim, quicquot plantato solo sedit, whatever is affixed to land belongs to the land, apply fully to minerals. Accordingly, the stools and traditional leaders had a major stake in mining. Individuals and families could mine on any part of their stool or family land, subject in most cases to the pouring of libation to seek the blessings of God, and other members of the community always respected the exclusive rights of the first individuals or families to mine on that part of their land. For strangers, however, an intended miner had to bring gifts to the stool in return of the right to commence mining. The stools were entitled to 1/3, and in some cases, half of the proceeds of the mine, and all gold mined were collected at the mine site. In places like Takwa, all the proceeds from Saturday's mining went to the stool, while the miner retained proceeds from other days. Some communities imposed taxes that miners had to pay from their gold, which was produced annually or for specific purposes like war. Apart from these physical customary rules, most communities had other customary laws that regulated mining and related activities generally. In some parts of Wassa, for example, panning for gold was allowed only on Tuesdays, Thursdays, and Sundays. Among the Asantis, sex was prohibited on the night before mining. And among the Achims, a miner had to appease the gods with the blood of a fowl anytime a rich gold was found, with the size of the fowl corresponding to the richness of the gold. The colonial era and the advent of statutory regulation. Mr. Chairman, the colonial history of our country is usually traced to the latest patent of 1821, which annexed the Gold Coast to the colony of Sierra Leone under the governorship of Sir Charles McCarthy, and the British Settlement Act and Foreign Jurisdiction Act of 1843, which empowered the British administration to exercise their powers outside the forts and castles. But formal colonization followed the bond of 1844, signed on 6 March 1844, to regularize the de facto powers the British had exercised outside the forts and castles. As a revered, astute lawyer and one of the founding fathers of our country, Joseph Boachi Dankwa explains, and I quote, "By the bond, a free people who were not subjects of the British sovereign voluntarily placed themselves under a binding agreement to the British Crown, in thereby diminishing and abrogating their ancient rights and liberties. They secured a better maintenance of their society, with a society based on a differently organized system of values," end quote. It is important to also mention that the leader of the chiefs who signed the bond of 1844 was then Omanhene of Denchira, King Kojo Chibua, with the other chiefs coming from Fanti and Asin towns, which were all rich in gold, with gold mining actively ongoing at the time. Throughout this period, the pre-colonial methods of mining and accompanying customary rules continued to apply, with new mining techniques for mining deep into the land, including the use of wood and rope to hold the top of the soil to prevent cave-ins developing over time. As more Europeans came in, some foreign tools for mining, like shovels, pickaxes, and shafts, were introduced. In the 1840s, a group of Dutch engineers introduced a hand-powered machinery made up of pumps, crushers, and wood for mining in the valley of River Butri. Local entrepreneurs also began investing in foreign machinery, but not all chiefs were susceptible to this change. Thomas Francis Garrard, the renowned legal historian and draftsman who dedicated many years to the study of the history of gold trade in Ghana, recounts how in 1861, one Thomas Hughes, a Fanti entrepreneur, invested in European mining machinery, only to be thwarted in its use by the chief of his village on grounds of suspicion and superstition. The chief forbade him from mining and destroyed all the machinery. Meanwhile, soldiers and journalists returning to England from the war with the Asantis between 1873 and 1874 kept telling stories about how rich the colony was in gold. This led to what Domet describes as, quote, Wassa gold rush, end quote, by the Europeans in the early 1870s and late 1880s. By 1875, a number of British had started trooping into the Gold Coast purposely for gold mining. Most of these early entrepreneurs were not successful, as they did not get the support of the British government, which was against invasion of the coast. A few of them, however, persisted, and by 1877, the lives of J.A. Sketley, M.J. Bonnet, E.T. McCarthy, C.J. Harvey, E. Ray, among others, had taken concessions in the colony. European mining companies also began moving into the Gold Coast. In January 1878, the first European mining company in the colony, the African Gold Coast Company, was incorporated and was followed quickly in the next 2 years by a Fuata Gold Mining Company, Mrs. Swansea and Company, Gold Coast Mining Company, Abontinkon Mining Company, Aboso Mining Company Limited, and Wassa and Ahanta Gold Mines Syndicates. These companies introduced crushing mills powered by steam engines and other heavy equipment into the mining industry. By 1882, there were said to be, quote, upwards of 100 tons of machinery and mining implements in use, end quote, in the Efuotu mine alone. The likes of F.C. Grant, John Saba, James Hitchin-Brew, and James Amisa also came together to form the Gold Coast Native Concession Purchasing Company to participate in the mining industry through the purchase and sale of mining lands. Several other companies emerged, both by Europeans and indigenous Africans. By 1895, there were 37 European mining companies registered to do business in the colony. Most of these companies, including those formed by indigenous Africans, though appeared to be interested in mining, were operating as real estate syndicates, buying supposed gold-rich lands and selling them off in portions. The practice was so widespread that the Commissioner for Takwa, Commissioner Higgins, warned the government that, and I quote, the indiscriminate granting of concessions will lead to serious complications in future unless rules and regulations are established for the guidance both of the European and native landowners, end quote. This warning set the tone for attempts to regulate the mining industry. First, it was a proposal by Ferdinand Fitzgerald, described by some of the literature as an African promoter, who proposed that the colonial government set aside and occupied Akan mineral lands for efficient mining companies operating in the territory. According to them, this was necessary for the development of the colony. Although his proposal was supported by the European mining companies, it was rejected on the grounds that the Crown did not have sovereign control over lands in the protectorate. A mining dispute in 1889 revived the discussions about taking over unoccupied mineral lands. Governor William Bradford Griffiths, who was governor of the Gold Coast between 1885 and 1895, proposed to the Colonial Office in London that the Crown declare the whole of the colony as a Crown land, so as to give the colonial government control over the territory and supervision over all concessions. Although the Colonial Office was convinced about the administrative and financial advantages of the policy, they were concerned that such action may lead to a revolution. They explored other proposals, including the vesting of the land in the Crown as trustee and the appropriation of all minerals in the Crown, leaving the land to the chiefs. The persistent push by Governor Griffiths, coupled with the indiscriminate felling of timber and the uncontrolled acquisition of land by mineral speculators, resulted in the Colonial Office agreeing to take over unoccupied lands. This resulted in the Crown Land Bills of 1894. Under the bill, all, quote, waste lands, forest lands, and minerals, end quote, were to vest in the Queen for the use of the government of the colony. And all future concessions were to be made subject to the approval of the governor, who was also entitled to receive all royalties from the concession. Wastelands were defined as unoccupied lands. The emphasis is mine. Opposition to the bill began the very day it was introduced into the Legislative Assembly in November 1894, on the ground, among others, that there was no such thing as, quote, wasteland, end quote, within the colony. Indeed, the nationalist and patriot, John Mensah Saba, recounts that Justice Smith in his report on land tenure in the Gold Coast in 1891, had advised the colonial government, and I quote, all the land in the colony, save what the government have from time to time taken for public purposes, has, according to native law, an owner, end quote. It therefore appeared surprising to the people that 3 years later, the Crown would seek to vest ownerless lands in themselves. They argued that the bill was in essence an expropriation bill designed to illegally seize lands belonging to the people. Several petitions were written against the bill, but Governor Griffiths hid all these petitions from the colonial office in London until Governor William Edward Maxwell took over as governor on 7th April 1895. The new governor forwarded all the petitions to London and called for a withdrawal of the bill for a more comprehensive legislation. While he opposed the bill in principle, Governor Maxwell expressed his full support of the validation of concessions by the colonial administration, a system which was practiced in the Malay state, now Malaysia, where he served as governor prior to his appointment to the Gold Coast. Through his instrumentality, a new bill, the Land Bill of 1897, was introduced into the Legislative Assembly on 10th March 1897. This new bill no longer sought to vest the lands in the Crown, but sought to vest the administration of the lands in the Crown. Under this bill, chiefs had no power to grant concessions to foreigners without the consent of the colonial government, and the government could declare any land as unoccupied and authorize its occupation. In practice, concessions were to be granted by the government using its powers of administration. Assessing the impact of the bill, Omosini opined that, and I quote, although this proposal was designed to ensure that European concessions got firm titles, in practice, it will have enabled the administration to grant concessions to whomever it pleased for the exploitation of mineral, forest, or agricultural resources. This will, in course of time, have threatened the traditional African system of small-scale peasant production if it became necessary to grant concessions to foreign capitalists to develop plantation agriculture, end quote. Again, this bill was strongly opposed both by the natives and the Europeans. The Aborigines Rights Protection Society was formed to fight the bill. They argued that the bill leaves African land rights at the mercy of the colonial government. John Mensah Saba, for example, described the bill as, and I quote, an elaborate and expanded form of the Crown Land Bill of 1894, end quote, and called for its total rejection. News of the protests and opposition against the bill quickly spread in the United Kingdom. Several meetings were held with the colonial office, and eventually this bill was also withdrawn. The colonial government, however, continued to explore means of regulating the mining industry. A new bill, the Concessions Bill, was drafted in consultation with the Aborigines Rights Protection Society. While the right to grant concessions remained with the chiefs, the bill contained provisions for the validation and registration of concessions and the payment of adequate consideration, which the High Court was empowered to supervise. Mining concessions were limited to 5 square miles, with no person to hold more than 20 square miles, 4 concessions in aggregate. The maximum period for a concession was pegged at 99 years, a practice which will eventually become the de facto maximum lease period for almost all leases in our country, and a 2% tax on profits from the concession. Because the involvement of the Aborigines Rights Society in the drafting of the bill was secured, it received massive support in the Legislative Assembly. And although the European mining companies protested against the imposition of taxes and the restrictions on the size and duration of concessions, the law was unanimously passed with few amendments as Concession Ordinance number 14 of 1900 and became the first statute to regulate mining and other natural resources in our country. Later in 1903, the Ashanti Concession Ordinance number 3 of 1903 was also enacted to regulate concessions in Ashanti. These ordinances underwent several amendments until they were repealed and replaced with the Concession Ordinance 1939, number 19 of 1939, which is still in force today as Concessions Act 1939, Cap 136. Mr. Chairman, Apart from regulating how concessions are granted and validated, leading to the grant of a mining lease, the law did not regulate mining operations itself. It was not until 1905 that the Mining Rights Regulations Ordinance, number 8 of 1905, was enacted to, quote, regulate the exercise of mining and ancillary rights, end quote. Under this ordinance, the governor was empowered to appoint a secretary for mines and an inspector of mines who were responsible for the general supervision of mining and mining rights and the inspection of mines to ensure health and safety standards. In the Northern Territories, a mineral rights ordinance, similar in terms to what existed in a colony and Ashanti, was enacted in 1904. But the Comprehensive Minerals Ordinance, number 20 of 1936, was later enacted to deal with all mineral and mining issues, from surveying to the disposal of minerals mined. Unlike its counterpart in the colony and Ashanti, the Minerals Ordinance vested all minerals within the protectorate in the Crown, and no one could prospect without a license from the Chief Inspector of Mines or mine without a mining lease from the Minister. Mr. Chairman, I will revisit this system as it will later become the legal regime for not only the mining sector, but all natural resources in independent Ghana. Mr. Chairman, as new minerals were discovered, specific laws were enacted to regulate their mining and trading. These include the Diamond Export Duty, number 12 of 1919, the Diamond Mining Industry Protection Ordinance, number 11 of 1926, and the Radioactive Minerals Ordinance, number 4 of 1946. Chairman, the respected lawyer and academic, Fuichi Kata, sums up the policy behind all this legislation into 5 main themes. 1, establishing legal and administrative framework to facilitate mineral operations. 2, ensuring security of tenure for grantees of mineral rights. 3, managing the problem that arose between mining companies and representatives and members of the local communities. 4, obtaining revenue for government through the levying of duties or income taxes. And 5, in the case of manganese and bauxite, to contribute to the self-sufficiency of the British Empire in war times. The post-independence era. Mr. Chairman, through the toil of our forebears, an independent nation called Ghana was eventually born on 6th March 1957, exactly 113 years after the signing of the Bond of 1844. By this time, Gold Coast Colony, Ashanti, the Northern Territories, and the British Togoland had all been merged into one state. Barely a year after independence, specifically in February 1958, the government set up a commission of inquiry into concessions, also known as the Boating Concession, to inquire into A, the terms under which mineral and timber rights are at present held, with a view to determining the consistency of the agreement with equity and with the present profitability of these industries, and B, the existence of all unexploited concessions and ascertain the concessionaires proposed to begin working therein, end quote. The commission finished its work and presented its report in 1961. The findings of the commission, though startling, were perhaps something that was already known to many. It found that the method of granting leases was obsolete, and grantors usually did not appreciate the economic value of lands they were giving away, with the result that in some cases, no royalties or inadequate compensation were paid. Agreements were usually drafted by the concessionaires, who were educationally and financially better placed than the grantors, and explained to the grantors by the agents of the concessionaires. In accordance with customary law, drinks were usually served before the interpretation and signing of the agreement, sometimes inducing agreements under the influence of alcohol. As a result, most of these agreements were oppressive to the grantors. In respect of unexploited concessions, the commission found that concessionaires secured large tracts of land not required for immediate purposes in order to defeat any future claim of grantors to rent and royalties, and some laid idle for over 30 years. Based on the foregoing, the commission recommended that to protect landowners and concessionaires, government must vest all mineral rights in itself. They also propose that royalties be made a percentage of profit instead of a fixed amount, and part of it allocated to landowners. Other proposals of the commission included restrictions on the size and duration of mining concessions, the power of the government to terminate mineral rights for inactivity, the acquisition by government of 51% shares in mining companies, and state monopoly over export of mineral. The government accepted most of these recommendations, leading to the enactment of a series of legislation to reform land administration and mineral rights. These legislation include the Land Registry Act 1962, Act 122, the Administration of Lands Act 1962, Act 123, the Concessions Act 1962, Act 124, the State Lands Act 1962, Act 125, the Minerals Act 1962, Act 126, and the Survey Act 1962, Act 127. The Minerals Act, in particular, was modeled around the Minerals Ordinance, which applied in the Northern Territories. The long title made its purpose very clear, as, and I quote, an act to provide for the vesting of ownership and control of minerals throughout Ghana, in the President on behalf of the Republic of Ghana, in trust for the people of Ghana, to enable the President issue prospecting, mining, dredging, and water licenses, end quote. Section 1 vested all minerals in Ghana in the President, in trust for the people of Ghana, subject to existing mineral rights. The power to grant mineral licenses also rested with the President. The Act gave the President preemptory rights over minerals won in Ghana and empowered the President to make regulations for limiting the area in terms of mineral rights. Mr. Chairman, writing in favor of this legal and policy decision, Professor S.K.B. Asante notes that, and I quote, with the reduction of stools to the status of subjects in the larger framework of the Republic of Ghana, it became clearly desirable to proclaim republic ownership of all minerals in Ghana. The charge of confiscation by an alien government had no application in independent Ghana, and the responsibility which had characterized the grant of mineral concessions by the various tools called for radical overhaul of the ownership of parties. This also found favor with my Lord Professor Samuel Dateba, who observed that, and I quote, a further reason for the intervention of the Ghanaian central government was the need to eliminate insecurity of title for investors in natural resource projects arising from conflicting or overlapping claims of stools to title over land. By vesting all mineral rights in the state, foreign and local investors now needed only to deal with the central government in relation to the grant of rights over the subsoil, although such rights remain vested in their usual owners, end quote. At this stage, as a proud royal, I need to make an obiter comment that the National and Regional Houses of Chiefs, being on the case of government and myself, that this arrangement ought to be looked at again. And we are taking a look at it. Mr. Chairman, the Administration of Lands Act and the State Lands Act gave the President wide powers in respect of the acquisition, use, and or management of any land within the Republic. And the Concessions Act 1962, which applied to concessions over stool lands, gave the President the power to cancel or modify the terms of existing concessions. Prior to these enactments, in 1961, a state mining corporation, which had been established, acquired 5 gold mines and a diamond mine from UK companies. Despite several changes in government, the legal regime of the mining sector remained intact, subject to few amendments, until the National Redemption Council, NRC, which overthrew the Second Republic, introduced its policy of, quote, taking over the commanding height of the economy, end quote. The purpose of this policy, according to them, was to indigenize some strategic business enterprises, including mines, to maximize government revenue and control resources and employment generation. Thus, by the Mining Operation Government Participation Decree 1972, NRCD 132, The government acquired 55% shares in all the foreign mining companies, except the African Manganese Company, which was completely taken over by the government under the new name, the Ghana National Manganese Corporation. This policy, coupled with other challenges like high mineral duties, royalties, and export taxes, led to a stagnation of the investment in the mining industry between 1972 and the early 1980s. According to Fuichi Kata, quote, the Ghanaian economy, including the mining sector, was in a state of crisis, end quote. Gold production had dropped from 900,000 ounces in 1960 to 232,000 ounces in 1982. Manganese from 600,000 tons in 1960 to 160,000 tons in 1982. Bauxite from 407,000 tons in 1974 to a paltry 64,000 tons in 1982. And diamond from over 2 million carats in 1975 to about 600,000 carats in 1982. Meanwhile, the 1979 Constitution had introduced two major changes to the legal regime of the mining sector. First, by Article 18914, all transactions involving the grant of mineral rights were made subject to ratification by Parliament. And Article 191 mandated Parliament to establish commissions for the regulation and management of the various natural resources within the country. The Third Republican Constitution was, however, short-lived and was overthrown by the Provisional National Defense Council, PNDC. Shortly after assuming the reins of power, the PNDC launched an economic recovery program in 1983 to, as they put it, quote, liberalize the economy and promote growth, end quote. As part of this effort, the PNDC attempted to undertake reforms in the natural resources sector, including the enactment of the Minerals and Mining Law 1986, PNDC Law 153, and the Minerals Commission Law 1986, PNDC Law 154, as a set of comprehensive laws to regulate the mining industry. Significantly, PNDC Law 153 gave the government a 10% carried interest in all mineral operations, with the right to acquire an additional 20% where minerals other than salt are discovered in commercial quantities, or 45% where salt is discovered in commercial quantities. The power to grant mineral rights was taken from the president and given to the minister responsible for mines, and only bodies corporate and unincorporated body of persons were eligible to be granted mineral rights. Holders of mineral rights were mandated to implement a program for the recruitment and training of Ghanaians with the ultimate aim of replacing expatriate personnel with Ghanaian personnel. The PNDC also started a program of privatization of state enterprises. A Diversity Implementation Committee, DIC, was established in 1987, and in 1989, a decision was taken to divest the state mining companies, particularly the Ghana National Manganese Company, the Ghana Consolidated Diamonds Company, and the State Gold Mining Company. These reforms yielded some positive results as gold production began increasing by the years. The capital-intensive nature of mineral operations meant that many Ghanaians were not able to participate in the mining industry. Small-scale gold mining, involving the use of rudimentary equipment, however, been going on underground and remain unregulated. The government of the PNDC thus sought to regularize small-scale mining through the enactment of the Mercury Law 1989, PNDC Law 217, the Small-Scale Gold Mining Law 1989, PNDC Law 218, and the Precious Minerals Marketing Corporation Law 1989, PNDC Law 219. PNDC Law 218 made it mandatory to obtain a license to engage in small-scale mining, which was defined as, quote, the mining of gold by any method not involving substantial expenditure by an individual or group of persons not exceeding 9 in number, or by a cooperative society made up of 10 or more persons, end quote. Licenses were to be granted only to Ghanaians and was not to exceed 3 acres in the case of an individual, 5 acres in the case of a group of persons not exceeding 9, and 25 acres in the case of a cooperative. The mercury law prohibited the importation and dealing in of mercury without a license, but exempted small-scale gold miners from the requirement of a license, provided they purchase reasonable quantities and observe good mining practices in the use of mercury. Here, ladies and gentlemen, we see the beginning of the introduction of mercury in small-scale mining, which has stayed with us till date, with all its attendant consequences on the environment. PNDC Law 219 established the Precious Minerals Marketing Corporation to assay, buy, and sell precious minerals, and to appoint licensed agents to purchase precious minerals from small-scale mining companies. Like the other policies, the formalization of small-scale mining sector increased production from that subsector and contributed to an increase in the overall gold production of the country. There were, however, concerns, particularly from international leading agencies, on the impact of small-scale mining operations on the health and safety of miners, water supply, and the environment. The current legal regime of the mining sector. Mr. Chairman, not much has changed with the advent of the 1992 Constitution. The state's ownership of mineral resources and the vesting of same in the President of the Republic on behalf of and in trust for the people of Ghana has been given constitutional backing by Article 2576. And Articles 268 and 269 repeats the 1997 constitutional provision on parliamentary ratification and the establishment of commissions for the various natural resources. Pursuant to the dictates of Article 269, Parliament, by the Minerals Commission Act 1993, Act 450, which came into force on 6 July 1993, exactly 6 months from the coming into force of the Constitution, established the Minerals Commission to regulate and manage the utilization of mineral resources and coordinate policies relating to them. The then government continued with the privatization scheme. Thus, towards the end of 1993, the Mining Operations Government Participation Repeal Act 1993, Act 465, was enacted to repeal NRCD 132, which had given the government 50% in all foreign-owned mines. Act 465 also converted the Ashanti Goldfields Corporation, Ghana Limited, and the Ghana Consolidated Diamonds Limited, which had been established under NRCD 132, to companies incorporated under the Companies Act 1963, Act 179. Shortly thereafter, in early 1994, the government announced its intention to sell half of its 55% share in AGC to private investors. This resulted in a serious debate about the government's divestiture policy. When it became clear that the government was willing to go ahead with this policy, some residents of Obuasi, relying on Article 2576 of the Constitution, which makes the president a trustee of the natural resources, sued for an injunction to restrain the government from going ahead with the sale. In its ruling, in the unreported case of Ajayi and others versus Attorney General and others, delivered on 30th March 1994, the High Court held that the trust created by the Constitution is, and I quote, trust in the higher sense, which is no more than government obligation, which is not justiciable, end quote. The emphasis is mine. Thus, although the president holds the mineral resources in the country in trust for the people of Ghana, a private citizen cannot bring an action to enforce that trust in the courts. While it is doubtful whether the High Court, in the light of Articles 21 and 1301 of the Constitution, had the power to interpret the nature of the trust created in the manner it did, it remains the only authority on the provision and effectively barred private actions seeking to direct the executive on how to manage the natural resources of the country. Needless to point out that AGC was eventually converted into a public limited liability company. It is my considered view that this is an issue worthy of further judicial interrogation. Be that as it may, Article 268 empowers Parliament as the people's representative to supervise the utilization of our mineral resources through the ratification of agreements granting mineral rights. This power seeks to ensure that the President, who is only a trustee, utilizes the natural resources for the benefit of the people, the actual owners of these resources. Explaining the rationale and effect of this provision, the Supreme Court, in the unreported case of Republic versus High Court, General Jurisdiction 6, Accra, ex-party Attorney General, Eston Cubic, interested party, delivered on 31st July 2019, held that, and I quote, the above provision, Article 2576, is very clear, and our understanding of it is that every mineral found in Ghana is for the Republic as a whole, and the President holds the mineral in trust for the people of Ghana, whose representatives are in Parliament. The constitutional provision in Article 268 that such mining leases shall be subject to parliamentary ratification derive its source and wisdom from Article 2576. The intention of subjecting any transaction involving the exploitation of any mineral to parliamentary ratification was to ensure that such transaction had received the approval of the actual owners of the mineral, the people of Ghana. Such approval expressed through their representatives in Parliament as engineered by the Constitution, end quote. The post-1992 legal regime, Mr. Chairman, remained largely intact until 2005, when the government introduced the Minerals and Mining Bill 205 to, quote, revise the existing law to reflect new thinking and developments in the mining industry and consolidate it with the enactment on small-scale gold mining, end quote. See the memorandum to the Minerals and Mining Bill, page 1. The overall objective of the bill was to bring our laws in conformity with international best practices and to reposition Ghana as a major mining investment destination through a legal framework that provides for a stable and equitable tax regime and protects the environment and community interests. The bill culminated in the Minerals and Mining Act 206 at 703, which came into force on 31st March 2006. While it largely reproduced the existing law, the 206 Act introduced some innovations to achieve the objectives set out in the memorandum to the bill. Key among them, the introduction of the cadastral system, Section 8, the requirement to give reasons when the minister refuses to grant an application for a mineral right, Section 5.3, the introduction of timelines within which application shall be processed, Section 12, the requirement of Forestry Commission and Environmental Protection Agency permits, and the introduction of Stability and Development Agreements, Section 48 and 49, as well as several changes in the fiscal policy of the industry. Small-scale mining, which by definition has been expanded to include all other minerals, continues to be the reserve of Ghanaians. Act 703, however, removed the restrictions on the number of persons who may engage in small-scale mining and the type of equipment that may be used for such mining. By its definition, small-scale mining is differentiated from large-scale mining only by the size of the concession, which is limited to 25.2 acres. Small-scale miners are thus not restricted by quantum of investment, equipment used, or the methods they employ to mine. The Act has seen several amendments, mainly on the royalties and offenses and penalties provisions of the Act. It is also important to note that pursuant to Section 110 of the Act, several legislative instruments have been made to give effect to the provisions of the Act. Key among them are: 1. Minerals and Mining General Regulations 2012, LI 2173. 2. Minerals and Mining Support Services Regulation 2012, LI 2174. 3. Minerals and Mining Compensation Resettlement Regulations 2012, LI 2175. Minerals and Mining Explosive Regulation 2012, LI 2177. Minerals and Mining Mineral Operations Tracking of Earth-Moving Equipment Regulation 2020, LI 2404. And Minerals and Mining Local Content and Local Participation Regulations 2020, LI 2431. Time will not permit me to go into the details of these regulations, which, together with the constitutional and statutory enactments mentioned, form the regime of the current regulation of the mining industry in Ghana. The health and safety regulations alone, for instance, has 561 provisions. The licensing regulations, LI 2176, has 279 provisions, and the explosive regulations, LI 2177, has 280 provisions. It is important, however, to add that because of the permits required from the state agencies like the Environmental Protection Agency, the Forestry Commission, and the Water Resources Commission, there are several other laws that a person seeking to invest in the mining industry must acquaint himself with. Mr. Chairman, ladies and gentlemen, now I move to the challenges. Despite these successes, the mining sector is still fraught with several challenges. Again, I cannot exhaust all the challenges that confront the sector in this lecture. I will thus highlight the major challenges and how we are dealing with them. 1. Mineral rights versus surface rights. The Constitution vests all minerals in their natural state in the President of the Republic, on behalf of and in trust for the people of Ghana. However, the lands on which the minerals are found remain the property of the stools, families, or individuals that own the land. From this same podium, in this very great hall, on the occasion of the first regional consultative dialogue on small-scale mining in Kumasi, our beloved King, Otumfuo Osei-Tutu II, raised the vast issue of how to strike a balance between mineral rights and surface rights. The holder of a mineral right will necessarily have to interfere with the rights of the owner of the land to undertake his operations. Although Section 72 of Act 703 attempts to protect the surface rights of the owner, even while mining operations are ongoing, it imposes restrictions that make the enjoyment of such rights almost impossible. This conundrum remains a challenge. Illegal small-scale mining. Since its formalization, small-scale mining has been the preserve of Ghanaians who are required to obtain the requisite licenses and permits before commencing operations. Unfortunately, over the years, foreigners and Ghanaians alike have exploited minerals at all parts of the country without any form of licensing whatsoever. The causes of illegal mining are varied. While most of them are as a result of a few greedy people who put their selfish interests above the collective good, the legal and administrative challenges associated with securing the licenses and permits for mining became a disincentive for the people to follow the law. There is even an issue with those who go through the process. Article 268 requires parliamentary ratification for, quote, any transaction, contract, or undertaking, end quote, involving the grant of a mineral right. This must necessarily include the grant of any right to undertake small-scale mining operations and the mining of industrial minerals like clay, kaolin, sand, failing which no right is acquired. Unfortunately, since the coming into force of the 1992 Constitution, not a single small-scale mining lease has been ratified by Parliament. Admittedly, it may not be the judicious use of legislative time to be dealing with small concessions of not more than 25 acres or a transaction involving the grant of a mineral right for sand winning, for instance. That is why the framers of the Constitution empowered Parliament under Article 2682 by resolution exempt any class of transaction from the requirement of ratification. Mr. Chairman, ladies and gentlemen, regrettably, Parliament has not made use of this provision of the Constitution. Until date, even an agreement to undertake sand winning requires parliamentary approval. Strictly speaking, therefore, even the holders of small-scale mining leases and holders of licenses of industrial minerals have no mineral rights. Just a couple of weeks ago, I received a petition where a holder of a quarry license who had sued to injunct some trespassers on his concession was rather injuncted by the High Court on the ground that he had no right to undertake the quarry operations for lack of parliamentary ratification of the agreement. You can hardly fault the court for coming to this conclusion, but you can obviously not fault the concessionaire for the non-ratification of the agreement. This, indeed, is a major challenge, and the emphasis remains mine. Environmental challenges. Mr. Chairman, closely related to illegal mining is the various environmental challenges that confront our mining industry. Section 18 of Act 703 requires a holder of a mineral right to obtain permits from the Environmental Protection Agency and the Forestry Commission before commencing operations to comply with all regulations relating to the environment to ensure the protection of the natural resources, public health, and the environment. And if such a person wants to make use of any water course, the person must, in addition, obtain a license from the Water Resources Commission. In respect of small-scale mining, Section 93 of Act 703 specifically enjoins them to use, quote, effective and efficient methods, end quote, of mining and, quote, observe good mining practices, health and safety rules, and pay due regard to the protection of the environment during mining operations, end quote. Mr. Chairman, Section 102 of Act 703 and Regulation 2 of LI 2182 empower the Chief Inspector of Mines and any other officer authorized by him to enter any mine and inspect compliance with health, safety, and environmental conditions, and to order the mine to stop operations if they are in breach of these conditions. Section 15 of the Environmental Protection Agency Act 1994, Act 490, also empowers environmental protection inspectors of the EPA to enter any premises at a reasonable time to ensure compliance with environmental laws of our country. Lack of personnel have, however, hampered these institutions from adequately policing compliance with environmental laws. Lack of appropriate geological investigations. Effective geological survey is sine qua non to developing an efficient mining industry. Without effective surveying, we will not know what we have and where they are to mine. While the Geological Survey Authority continues to find more minerals in the course of their work, lack of resources, including portable drilling rigs, laboratory equipment, among others, has over the years posed a challenge to undertaking adequate geological investigations to determine what we actually have. Local content. Mr. Chairman, our mining laws did not protect local content until the enactment of PNDC Law 153 in 1986, which introduced the PNDC's, quote, localization policy, end quote, into the law. By Section 54 of the law, holders of mineral rights were required to submit to the Minerals Commission a detailed program for the recruitment and training of Ghanaians with the aim of eventually replacing expatriate personnel with Ghanaian personnel. More than three decades after this law, we still have a lot of expatriates mining key aspects of mining operations. I am not a mining engineer, but I think it is fair to ask, how long does it take to train a personnel for the mining sector? This same provision has been repeated in Section 50 of Act 703 and has been made a condition precedent for the grant of a mining lease. In 2020, we undertook a comprehensive review of the local content law, leading to the promulgation of the Minerals and Mining, Local Content and Local Participation Regulations 2020, LI 2431. This regulation reserves certain services like catering, haulage, fuel supply, security services, legal services, financial services, and insurance services for Ghanaians and professionals licensed to practice in Ghana. The Minerals Commission is also empowered to, from time to time, publish a list of goods and services which holders of mineral rights are to procure within the country. Mining companies and companies registered to provide mine support services were given 1 year to undertake arrangements for complying with the law. With the year having elapsed, it is my fervent hope that we will see more local participation in the mining industry of our country. Lack of value addition. For the thousands of years we have been mining, Mr. Chairman, we have failed to invest in value addition. There is currently no gold refinery operating in the country. As a result, all our gold, both from large-scale mining and from small-scale mining, are exported in their raw state to be refined outside the country. Because of the absence of a refinery, we have to export all our bauxite in their raw state and then import alumina, which is the refined bauxite, into the country to be processed by the Valco Aluminium Company, Valco. But the real benefits of these resources lie in value addition. That is why even countries that do not have some of these resources have created a system that allows them to import the raw materials and process them there. By exporting these raw materials, we are unable to reap the full benefit of our mineral resources for the benefit of the country and its people. Lack of access to funding. One of the reasons for the involvement of foreigners in the small-scale mining sector is lack of access to funding. As a result of this difficulty, they easily engage foreigners who have the capital, but who, by law, are forbidden from participating in small-scale mining, either directly or indirectly, and draw them into the sector. Finally, over-concentration on gold. Mr. Chairman, ladies and gentlemen, gold remains the foremost mineral, constituting over 90% of all minerals mined in the country. But we are blessed with several other minerals, including bauxite, manganese, iron ore, limestone, clay, kaolin, mica, colobite, tantalite, feldspar, silica, silica sand, quartz, salt, ilmenite, magnite, and rutile. So you can imagine, Ghana is a very rich country, you know. Rich in resources. Despite the large deposits of bauxite in Atiwa and Yinahini, since colonial times, the only developed bauxite mine is the Awaso mine. In fact, most of our laws have been made with gold in mind, even though they are meant to be applicable to the mining of industrial minerals generally. The country is therefore losing out on these unexploited mineral resources. The way forward, a mining industry that benefits Ghanaians. Mr. Chairman, Nana Bompata Hene, ladies and gentlemen, it must be reiterated that the natural resources of our country are the property of the people of Ghana, vested in the President as a trustee, to be held in trust for the people of Ghana. Government, therefore, has an obligation to ensure that the exploitation and utilization of these resources benefit the actual owners of the resources, the people of Ghana. This is exactly what the people of Ghana and the international community expect from us. The United Nations Declaration on Permanent Sovereignty over Natural Resources, adopted by the UN General Assembly in December 1962, requires that the sovereign right over natural resources be exercised in the interest of national development and the well-being of the people of the state. The African Mining Vision, adopted by the first conference of the African Union ministers responsible for mineral resources development in February 2009, advocate for, and I quote, transparent, equitable, and optimal exploitation of mineral resources to underpin broad-based sustainable growth and socio-economic development, end quote. And the ECOWAS Mineral Development Policy call on us to use the exploitation of our mineral resources as a key element of strategy for industrialization. The Ghana Mining Policy, adopted in 2014, has as its main objective the development of a thriving mining industry that contributes to the sustainable economic development. There is indeed no doubt that a developed mining sector will contribute immensely to sustainable development. Accordingly, the vision of the President of the Republic, His Excellency Nana Addo Dankwa Akufo-Addo, is to make Ghana the mining hub of Africa, where all mine and mine-related activities, from exploration to finished products, and from research to innovation, will be centered. This industry must be largely indigenous, with strong local content participation, and adopt environmentally sound schemes. Achieving this vision requires that we put in measures to create the enabling environment to both the upstream
and downstream mining industry to prosper. It is in the light of this vision that I approach the way forward of our mining industry, policy and legislative reforms. Mr. Chairman, creating the conducive environment for the mining industry must begin with assessing the existing constitutional, legal, and policy regime of the industry. The Ministry of Lands and Natural Resources has therefore begun the processes of undertaking a comprehensive review of all laws and policies that affect the mining industry. The current minerals and mining policy, which was adopted in 2014, requires that it be reviewed at least every 5 years. This is necessary to ensure that the policy direction of the mining industry responds to the changing dynamics in the industry. As most of our existing laws were passed before the policy was adopted, we must also review our laws to ensure that they align with our policy objectives. Such a review may lead not only to legislative amendments, but also constitutional amendments. For example, why does Article 268 of the Constitution require parliamentary ratification for mineral transactions instead of prior parliamentary approval, as is the case for loans and international business transactions under Article 181? Prior approval gives Parliament more room to scrutinize the agreements before they are executed. With ratification, only a completed agreement is presented to Parliament for its endorsement or otherwise. We have to examine whether the parliamentary ratification, as opposed to prior approval, best serves the purpose of the provisions and ensures value for money. Another important matter worthy of examination, particularly having regard to Parliament's refusal to exempt certain transactions from ratification, is whether parliamentary ratification should continue to apply to all minerals, or whether the Constitution itself, instead of Parliament, should create the exemptions. I am informed that previous attempts to get Parliament to exempt certain industrial minerals like sand and clay have not been successful. It is a matter worth revisiting to ensure that we do not perpetuate unconstitutionalities or continue to operate in the framework of absurdity. Value addition to mineral resources. Mr. Chairman, our mining industry does not have much linkages to the other sectors of the economy because of lack of value addition. While extracting our mineral resources and exporting them gives us quick money, it deprives us of the full benefit of our mineral resources. We have to make a choice between remaining primary mineral producers forever at the mercy of fluctuating commodity indices, or taking full advantage of mineral value chains to promote the industrialization and the structural transformation of our economy. Over the years, the only attempt that had been made under the government of President Nkrumah to add value to our mineral resources was the construction of the Akosombo Dam and the establishment of the Valco Aluminium Company, Valco, to operate full integrated aluminium industry. But despite the involvement of global giants like Kaiser Aluminium and chemical corporations and Alcoa, till date, we have not been able to build that integrated industry. While building an integrated industry requires long-term investment, our failure to make such investments over the years has deprived us of the much-needed capital that will accrue for such investments. It therefore became necessary to put in place a legal regime that will bind current and successive administrations to commit resources to building that integrated industry. Accordingly, under the leadership of President Akufo-Addo, by Act 976 and Act 988, we have established the Ghana Integrated Aluminium Development Corporation, GIADE, and the Ghana Integrated Iron and Steel Development Corporation, GISDEC, to promote and develop integrated aluminium and iron and steel industries, respectively, in the country. A couple of months ago, GIADE launched its 4-scheme agenda to expand the existing mine in Awaso, develop 3 additional mines in Chebi and in Yinehini in Pasaso with refineries, and expand and modernize Valco to process alumina from bauxite mined in Ghana. A strategic partner, a wholly owned Ghanaian company, has already been identified, and an agreement has been signed to develop the Yinehini in Pasaso mine together with a refinery. The 3 new mines, together with the existing one in Awaso, are expected to produce 10 to 20 million tons of bauxite annually. With the refineries in place, we expect to refine approximately half of the bauxite we mine and export the other half. VALCO will no longer have to import alumina, but process alumina produced here in Ghana into primary aluminium to spare up the downstream industry. Mr. Chairman, ladies and gentlemen, this will guarantee full integration and value addition across the bauxite to aluminium value chain and ensure that money from these minerals stay here, right here in our country, Ghana. The same is being done for iron ore. GISDEC is currently developing a master plan which will ensure full integration from the mining of the ore to the production of iron and steel. Gold, which is our flagship mineral, is not being left out. The Precious Minerals Company Limited, under the leadership of its hard-working managing director, and Royal Ghana Gold Limited, have entered into a partnership for the construction of 400 kilograms per day capacity refinery, which is about 90% complete. When completed, we expect to refine some of our gold here in Ghana. The government intends to exercise its preemptive right under Section 7 of Act 703 to ensure that we retain enough gold in the country for the refinery to continue operations. The Bank of Ghana has also begun the purchase locally of gold to shore up its gold reserves. Working with the Ministry of Finance, we have also commenced processes to secure a London Bullion Market Association certification. LBMA is an internationally standard-setting organization that defines how precious metals are refined and traded around the world. Securing the LBMA certification will enable Ghana to refine its gold to be exported and traded easily on the international global marketplace. With these measures, we are hopeful that we can move away from the Goggisberg economy to actual value addition. Mr. Chairman, Bloomberg research conducted by Kwasi Apofo estimate that by the year 2040, over 65% of vehicles that will be sold across the world will be electric vehicles. And the world will need close to 5,000 gigawatts hour of lithium-ion battery per year to power these vehicles. It is also estimated that the lithium industry, from mining to production and assembling of these energy-friendly batteries, will grow to about 1.1 trillion United States dollars by 2035. Clearly, we cannot continue to rely on the traditional minerals if we are to reap the full benefits of our natural resources. Ongoing exploration shows an initial mineral resource estimation of 14.5 million tons of lithium oxide, containing approximately 189,000 tons of lithium. We therefore have to put in place the necessary framework to see to the full exploitation of lithium. For as the experts have pointed out, lithium is the future of the mineral resources of the world. Local content. One of the ways of ensuring that our mineral resources benefit the actual owners, the people of Ghana, is to ensure local participation in the extraction and development of these resources. Unfortunately, most of us are unable to participate in actual mining because of the capital requirements of the industry. The local content laws seek to ensure that Ghanaians play a critical role in the extraction of our minerals for their benefit. The Minerals and Mining, Local Content and Local Participation Regulations 2020, LI 2431, which came into force at the later part of last year, has made a lot of inroads into ensuring true local content and local participation. Under these regulations, holders of mineral rights, export licenses, and mine support licenses are required to submit a localization program for the recruitment and training of Ghanaians for the approval of the Minerals Commission, and to submit annual reports on the program to ensure local participation. The law also reserves certain enterprises for Ghanaians or joint venture with greater Ghanaian participation. The Minerals Commission is empowered under Regulation 7 to publish in the Gazette a list of goods and services which mining companies and mine-related entities must purchase from Ghana. The fourth revised edition of the list published this year reserved very important aspects of the industry for local companies. These include contract mining for surface mining operations, ground engagement tools, horses and fittings, overall and wet clothes, soil sampling and rock chip sampling, warehousing services, among others. The procurement of these goods and services in Ghana generate over $1 billion each year, which but for the regulation will have been exported. Of critical importance is Regulation 8, which requires the Minerals Commission to collaborate with the mining industry, universities, research institutions, and technical and vocational institutions to develop guidelines for applicable areas of training, research, and skills development. As the Intergovernmental Forum on Mining, Minerals, Metals, and Sustainable Development, IGF, puts it, a successful local content policy requires building capacities of local businesses and suppliers to ensure that they are able to take up opportunities unlocked through local procurement regulations. The universities, including my own, Kwame Nkrumah University of Science and Technology, must take this charge seriously and develop curriculum and training programs that will give Ghanaians the requisite knowledge to participate fully in the mining industry. It is only when we are able to train our people to acquire the requisite skill and expertise that we can take full charge and control of the sector. The Minerals Commission can add to the procurement list and decrease employment quotas if we build the necessary capacities. Mr. Chairman, distinguished guests, ladies and gentlemen, let me give a firm assurance on behalf of the government of President Akufo-Addo, myself, and the Ministry of Lands and Natural Resources that we will vigorously and tirelessly pursue local content initiatives until such time that the Ghanaian takes the commanding height of the mining industry. For after all, the minerals belongs to us. Mining communities development. Mr. Chairman, ladies and gentlemen, despite the huge returns we get from mining, most of our mining communities remain impoverished, in addition to the health and environmental hazards they face. The often asked questions are, why is Obuasi not like Johannesburg? Or why is Takwa not like Cape Town? By the Mineral Development Fund Act 2016, Act 912, a Minerals Development Fund was established to provide financial resources for mining communities, including the landowners, traditional authorities, and the metropolitan, municipal, and district assemblies where these minerals are mined. The Act establishes mining community development schemes to be managed by local management committees made up of members drawn from the community. It is long overdue that we work with all stakeholders to ensure that the communities who suffer the adverse consequences of mining get the benefit of the resources where they are found. Mr. Chairman, the destruction to the environment that has been caused by illegal small-scale mining has resulted in people associated small-scale mining with environmental destruction. But a well-organized small-scale mining will contribute immensely to our socio-economic development through job creation and increasing government revenue. As I noted earlier, the small-scale mining contributes about a third of our total gold production. Currently, all our diamond production comes from small-scale mining. The government is therefore not against small-scale mining. What the government is against is illegal small-scale mining that pays no regard to the environment and the lives of the millions of people who depend on them. What we must do to ensure that we benefit from small-scale mining is to sanitize the industry. Since March 2021, we have adopted several policies and measures to ensure that we deliver an environmentally safe small-scale mining for the good of our country. In April this year, we held a national consultative dialogue on small-scale mining under the theme, quote, Sustainable Small-Scale Mining for National Development, end quote. The dialogue, which was broad-based and non-partisan, solicited diverse views to develop an appropriate policy to ensure that the small-scale sector contributes to national development without destroying the environment. The dialogue resulted in a 15-point resolution, which the ministry is religiously implementing. Subsequent to the national dialogue, we have also held 2 regional dialogues, one here in Kumasi under the distinguished patronage of His Majesty the Asantehene, and another in Tamale under the distinguished patronage of Yana. We have been engaging all stakeholders to get their buy-in in the implementation of our policies. We have engaged the Council of State, the National House of Chiefs, all 16 regional ministers, the regional security councils of 13 regions of our country, the regional houses of chiefs of 12 regions, civil society organizations, the Ghana Chamber of Mines, the leadership of the Small Scale Miners Association, miners in the field, among others. The outcome of these engagements have been positive. Already, the government has allocated over 20 million Ghana cedis in the 2022 budget statement for the regional security councils to lead the fight against illegal mining in the regions. River bodies and forest reserves have been declared red zones and no mining is permitted. We have established a monitoring and evaluation team together with a situation room to receive reports on illegal mining and to act on them swiftly. Operation Halt was launched to clear illegal miners from river bodies of our country and to demobilize and or decommission all equipment used for illegal mining on the water bodies of our country. Some have argued that the demobilization and decommissioning of such equipment is illegal. Respectfully, I beg to differ. It is true that Section 99 of Act 703 as amended requires prosecution and conviction before forfeiture to the state. But as I noted earlier, it is not always that you meet people with these equipment. In some cases, the equipment are rendered immobile by the perpetrators of these heinous crimes, even before the task force gets to where the operation is to take place. How are such equipment to be forfeited to the state then? There are two reasons that justify the action taken by the state. First is the state's duty to protect the fundamental human rights of those who depend on these river bodies and the environment generally. And second is the state's duty to safeguard the national environment for posterity. Article 36(9) enjoins the state to, quote, take appropriate measures needed to protect and safeguard the national environment for posterity, end quote. And Article 41K imposes a duty on every citizen, quote, to protect and safeguard the environment, end quote. The state, as the custodian of the national environment, therefore, has a duty to protect the environment from destruction by adopting measures that are necessary to ensure such protection. One of such necessary measures, after trying several unsuccessful ones, is to decommission and or demobilize equipment used in illegal mining so that the perpetrators of these heinous crimes will not go back to the illegality with the same equipment. Mr. Chairman, ladies and gentlemen, I am fortified in this view by the provision of Article 41K of the Constitution, which says that, and I quote, the exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations, end quote, including the duty to protect and safeguard the environment. I forcefully submit a person who breaches this fundamental duty cannot turn around and complain about his right to the property used for the illegal act. To borrow the words of the President of the Republic, quote, no right can accrue to or flow from the criminal venture of Galamsey, end quote. Mr. Chairman, ladies and gentlemen, the principle of law established by Lord Mansfield, CJ, as far back as 1775 in Holman and Johnson, 1775, 1 Corpus Report, 341 at 343, is that, and I quote, est tepi cosa non orita osio, end quote, literally meaning, quote, from a dishonorable cause, an action does not arise, end quote. This principle of law has been applied in a long line of cases in our country, including the case of Hakwade Flour Mills Limited and Samia Faris, 2005-2006, Supreme Court of Ghana Law Report at page 882, where our apex court, the Supreme Court, speaking through the renowned Ansar JSC, held as follows, and I quote, the law was settled that no one could found an action on an illegal act where the express words of a statute expressly prescribed or forbade a transaction which a plaintiff sought to enforce. No court will lend its assistance or give effect to it, end quote. Mr. Chairman, the destruction of the environment and the river bodies of our country through this illegal act is contrary to the duty of citizens as enshrined in Article 41K Supra. This constitutional provision makes it abundantly clear that the enjoyment of right is inseparable from the performance of the duty to protect the environment. Indeed, the Supreme Court has on several occasions, beginning with the cases of Attorney General versus Faro Atlantic Company Limited, 2005-2006, Supreme Court of Ghana Law Report at page 271, through Attorney General versus Balkan Energy Limited, 2012, to Supreme Court of Ghana Law Report at page 998, to the Wyoming, Waterville, and Isophoton line of cases, held that no right can accrue from an unconstitutional act. Mr. Chairman, I have no doubt that we are on firm grounds. We will continue to employ all necessary measures to fight the canker of illegal mining. And as part of efforts to encourage responsible small-scale mining, we are instituting Responsible Small-Scale Mining Award Scheme to reward small-scale miners who adhere to the health, safety, and environmental standards. The maiden award ceremony will be held on Wednesday, 22nd December 2022, and it will be a yearly event. While undertaking policy and legislative reforms, the Minerals Commission must also be reformed to perform its regulatory functions properly. We cannot, for example, fight illegal mining if the Inspectorate Division of the Commission is not adequately resourced to monitor the operations of miners. We cannot regulate illegal mining if officials of the Minerals Commission and the Inspectorate Division of the Commission do not execute their work on the principles of integrity and transparency. Mr. Chairman, we cannot regulate small-scale mining if the minister, deputy ministers, and officials of the ministry who have the responsibility to offer supervisory duties do not do so on account of integrity. We can only get to the right conclusion in respect of sanitizing the small-scale industry if we work, all of us, Minerals Commission, Inspectorate Division, the minister, deputy minister, the ministry, work in a spirit of integrity and courage. That is the only way forward. No program to sanitize the small-scale mining industry will be successful if we do not create alternative employment and livelihood for the millions of people who depend on illegal mining and related activities for their livelihood. When the government launched Operation Hall 2 to rid our river bodies and forest reserves of illegal mining, an estimated 1 million people were displaced by the operations in Ashanti, Central, Eastern, Western, and Western North alone, where the operations were carried out. These include small-scale miners, fuel suppliers, hoteliers, metal fabricators, transport operators, caterers, food vendors, traders, farmers, among others. If no alternative is provided for these people, they will return to the illegalities once the security officers leave the site. It is in this spirit that we are determined to pursue a robust alternative livelihood scheme for illegal miners. Mr. Chairman, having regard to the contribution of small-scale mining to the mining industry over the years, it is important that we mainstream small-scale mining in any policy that seeks to make Ghana the mining hub of Africa. At the same time, we cannot condone the negative impacts of illegal and irresponsible small-scale mining on our environment and the river bodies. We must therefore put in measures that promote small-scale mining while protecting the environment. This is why we have launched the community mining scheme. Mr. Chairman, Nana Bompata Hene, distinguished guests, ladies and gentlemen, the legal regime of the mining industry had developed from a combination of customary law and British colonial laws. The vesting of natural resources in the president after independence was necessary to protect the resources and to utilize them for the benefit of the nation. The current legal regime has served us well, but there is more room for improvement. Perhaps the faculties and law schools have not taken a critical look at our laws to critique them for improvement. While I am aware that most faculties study natural resources law, the combination of mining and petroleum in one course of study does not allow enough time to deal with the issues to do with mining and/or petroleum. As you can see, an attempt by me as Minister responsible for lands and natural resources and a non-expert in mining and its laws, to discuss, quote, the legal regime of the mining sector in Ghana, history, challenges, and the way forward, end quote, has taken me some considerable time and effort to expose just a few of the consequential issues in the sector. I am therefore on terra firma when I advocate for a dedicated course of study on this subject at the faculties and all levels of our educational system, as an enhanced understanding of this sector will greatly advance our national development. Mr. Chairman, shortly after the discovery of crude oil in commercial quantities, the University of Ghana School of Law, where I obtained both my LLB and LLM, introduced a master's degree in oil and gas. Yet, for all the centuries we have been mining, we have not thought it fit to introduce a course of higher studies in mining. It is my hope that this lecture will set the tone for a broader conversation on mineral and mining laws, and perhaps the introduction of mining law as a separate and distinct course at the faculties, and the introduction of a master's program in mining in its own strength. This, in my reasoned view, will create a platform for students, lecturers, industry players, regulators, and all and sundry to constantly critique and review our laws to ensure that they suit the needs of our nation. More importantly, the review of our laws must respond to the needs of the youth, who are the backbone of our economy. According to the 2021 Population and Housing Census Report, our population is transitioning from one dominated by children to one dominated by young people between the ages of 15 and 35, who constitute 38.2% of our national population. And it is absolutely encouraging that in every corner of our country, young men and women are passionately and boldly interrogating the issues of our time, be it governance, economy, foreign policy, or the environment. Africa is not a scar on the conscience of the world. The future of the country rests with the youth, you, students of the Ghana School of Law, and we must invest in them to take the nation to the next level. It is said that the youth are the greatest asset of every nation, but it is also true that if we fail to invest in the youth and equip them with the necessary skills, they will become our biggest menace. To quote the words of former United Nations Secretary General and one of our most illustrious citizens, Kofi Annan, quote, young people should be at the forefront of global change and innovation. Empowered, they can be key agents for development and peace. If, however, they are left on society's margins, all of us will be impoverished, end quote. Mr. Chairman, we must build a progressive mining industry, indigenous, sustainable, environmentally sound, and viable mining industry ought to be and is our goal. This industry must contribute to our national developmental aspirations and help us to create a society of boundless opportunities for Ghanaians, particularly the young men and women of our country like myself. Mr. Chairman, we must leverage on all the natural resources of our country for the good of the nation, particularly her youth. The youth of Africa are awake and palpably determined not to settle for less. Whether in Accra, Addis Ababa, Cairo, Abidjan, Bamako, Ouagadougou, or Juba, the consciousness of the youth of Africa is at an all-time high. Mr. Chairman, the Ministry of Lands and Natural Resources and I are determined to continue to work tirelessly to construct a lands and natural resources sector which is effectively managed, transparent, and anchored on integrity, thereby contributing to the realization of the noble vision of the President of the Republic, His Excellency Nana Addo Dankwa Akufo-Addo. In his words, and I quote, "We will set upon the path to build a Ghana that is not dependent on charity, a Ghana that is able to look after its people through intelligent management of the resources with which it has been endowed. That is our path, and this path offers a new Ghana. This Ghana will be defined by integrity, sovereignty, a common ethos, discipline, and a shared value system. It is one where we aim to be masters of our own destiny, where we mobilize our own resources for the future, breaking the shackles of the Goggisberg colonial economy and a mindset of dependency, bailout, and extraction. I thank you for your attention.